Hi, this is my complaint to Lord Grade of Yarmouth about Ofcom. So, Lord Grade, there's quite a few problems that actually all tie in together to do with Ofcom and the Advertising Standards Authority. And actually what I've realised, this is as I have been learning about from the right to petition and about political rights, and a long struggle to get that recognised through the courts. It used to be recognised because it used to have its own proceedings. But petitioning involves canvassing, advertisements, collecting signatures. It's a mesny process, or it's a civil mesny process, but it's meant to be under the High Court of Parliament. Now, people used to put adverts in newspapers, and now that has been replaced by platforms. Now, this problem is actually around the Americans. I think the Americans are really to fault through this Section 230 of their Online Digital Media Act. The Section 230 that they've got claims that they can remove constitutionally protected material, right? But they're only protected from civil liability in civil cases. Now, what I've learned, and this is like what I've only learned within the last month or so, a few weeks, is that when I eventually found the key piece of information that I was looking for, I've had to learn all about political rights and the right to petitioning from the start. And when I get to find the parliamentary practice books of Erskine May, I knew about Erskine May. I should have really found this out in 2015. But because I got Lord Hanningfield's legal representation, the Jeremy Johnson one, and I didn't follow up all the citations in that legal document, if I had more interest in the citations rather than just getting the document itself and the legal representation, I had other things to focus on at the time, so I just didn't focus in on the citations and following them all up. And that's what led me to discover what Erskine May is, because the Parliament have got a whole page on this, but they've only more recently put those pages up there. Now, the Erskine May books, all the way through, because I've got some of the older ones, they've got this special section on misconduct against petitioners, and this is the actual key to all these protest arguments, all of the activists, the demonstrators, people who are doing petitions online and sharing them online and using platforms, and also the conduct of the platforms and what the platforms are doing. And I want to demonstrate how this actually extends to and includes, like Russell Brand and his channel is being demonetised. Richard Verb's, for example, his channel's been demonetised. And then you go into channels like Resistance GB and all of the other channels they're identifiable as having a side, a political side and a political challenge even, right? They might have petitions and they might be doing petitions. They might be sharing them. I mean, I think Russell Brand actually shared that Don't Pay UK advert, which was actually, that was a petition campaign, Don't Pay UK, right? Before he got demonetised. Now, I'm going to go to the legal part. So this is the page from Erskine May. And this section of the book, this is from the 1946, but it's exactly the same in the 1964. And the newer versions from around the Sir Malcolm Jack time, I think that was 2011, kind of like try to hide this information. But it's in the older ones and in the manuals of procedure in public business. But this page, if I would have found this page in 2013, and if I'd have found it in 2015, let alone in 2011, I wouldn't have had all the problems that I've got now, because when I was representing myself, I would have been able to use this, and it's very compelling and powerful evidence to support everything that I claimed anyway, but there was just so much doubt in it from other parties. But this is very clear, and we need to know this and learn this. So, misconduct affecting petitioners and others, so not just petitioners, soliciting business before our House of Parliament. Before is always understood as in order to, in the process of. So that's like mesne civil process. Like canvassing is in order to collect the signatures, in order so you can hand them in and the claim can be made, right? The Parliamentary Papers Act is meant to protect all this. It fully protects a newspaper, even doing abstracts of parliamentary petitions even. And even speaking about them after they've been published. So in order to collect the signatures and get it into Parliament, it has to be under the same protection. Now, this misconduct, this is actually when I've realised, Michael Grade, what's actually going on with the platforms in truth. And this is actually a really important revelation into the whole thing. And some of the conduct of the MPs, like Lucy Fraser MP, who was the Secretary of State for Culture, Media and Sport. Lucy Fraser actually acted personally in government and caused Russell Brand to get demonetised through her actions. Yet, that was because of her legal case. Russell Brand had a legal case, right, which arose. And in those processes and proceedings, or in connection with them, or because of them, Lucy Fraser chose to act, resulting in Russell Brand to get demonetised, right, when he hadn't been convicted of an offence. In a committee meeting, I need to indicate that they stated, for example, in the Stop ULEZ petition debates, that they aren't allowed to touch on matters of legal cases without permission of the Speaker, because it could affect any of the parties or the case, but also of it could affect the parties themselves, right? They won't comment on them at all. So Lucy Fraser actually was doing the equivalent of a select committee meeting or the petitions committee debate, talking about a legal case and somehow affecting one of the claimant or the respondent or the case. Surely, Michael Grade, because Lucy Fraser, because of a legal case which arose when a person hadn't been proved guilty, she wrote to a platform and affected it to cause his income being affected. Now, what happens if his legal case defence would have been funded by that income from YouTube? So, Lucy Fraser, really, I think she broke the parliamentary rules at that point and possibly even the law. And, even if she was privileged of Parliament, she should have been subjected to... they should have had to remedy, but this is the thing, right? Petitioners or others soliciting business to Parliament, right? So political matters, parliamentary business, and this is when we get into that Section 230 of the American Digital Media Act, which says that claims that platforms can remove things even if they're constitutionally protected, but it says in civil matters or claims. The thing is, when you, from this Erskine May, intervening in petitioners' activities or proceedings, right, is a contempt, just like if you interfere with a legal case, it's a contempt. But it's a criminal contempt. If you type in what is the difference between a civil contempt and a criminal one, right, a civil contempt is like if you breach an injunction, right? But if you're in a civil case, but you disrupt proceedings or break the law in a civil case, that's a criminal contempt. It's not a civil contempt just because it's civil proceedings. It's a criminal contempt because it is the offence of disrupting a legal proceeding, right? So when you disrupt proceedings or intervene in proceedings, right, whether it's in the court or out of the court, that's a criminal contempt. That is why certain communications are protected between solicitors and their clients as well, right? Also like witness appeals, really. So the thing is that if you are doing a petition like I was, and if your channel is for the petition, to promote the petition, to collect signatures for the petition, to talk about it and possibly raise any issues with the public, why should they sign it, give evidence or reason why they should sign it, well, that is some kind of evidence, right? Why should they sign that petition? That's inclusive of, all statements and so forth. Removing that channel or seizing it, taking it unlawfully, right, that is a criminal contempt under this, because it is interfering with interfering with the duties, exercise of their functions, rights, and the discharge of their duties. It's the processes of petitioning, right? So Google, YouTube have broken the law. They've broken the law, and it's a contempt. In England, we don't have that Section 230 law of the Digital Media Act like in America. So, and even in America, when Bill Clinton, and the American government made that act, I don't think that it's defective because it only protects the platform from financial liabilities, okay, from financial claims against them. That's a civil claim for removing constitutional material. But the removal of the constitutional material, Michael Grade, it is a criminal contempt. And if it's a criminal contempt, you've got a right to prevent the crime from happening. We've got a right to intervene in it, like prevent it from being seized or obstructed. I mean, YouTube's in America. I don't know how we're going to do that, but, they've got offices in England. It is a criminal contempt. You can actually prevent them from removing it. Just like, once a newspaper's printed, you don't do all this removal business, right? If a newspaper gets printed, it's done, right? They sell it, everyone's got it. If there's a legal challenge, people get prosecuted, right? But the newspaper is printed, it's done, right? Now, this is the thing. Now, so it's important. Now, the thing is, I didn't realise how... I knew it was important and serious, but I didn't realise how important and serious it is if these places are taking over newspapers, and newspapers are becoming online or on websites, and newspapers are becoming not the go-to way of promoting things, or using leaflets or pamphlets or word of mouth. When these platforms are taking over the entire arena of all material, digital content, all content's going digital now, right? They're effectively... They're trying to claim that they're given a right to complete and total, if they wanted to, any reason or no reason, every time, a claim that they might be able to or could be able to completely and totally censor everyone's political opinion anytime they wanted, but based on any reason or no reason when it comes down to it, even if it's constitutionally protected, which would mean that you haven't got any protection. But we have, because that Digital Media Act for indecent material, that Section 230, it only says civil, and it's a criminal contempt. Here it is a contempt against the High Court of Parliament, and criminal contempt is interfering in proceedings, which is why if you stand up in a court, and misbehave, that is a criminal contempt. It's not a civil contempt. Breaking an injunction is a civil contempt, but not disrupting proceedings. It doesn't matter whether they're civil proceedings or criminal proceedings. And Parliament's the High Court of Parliament proceedings, right? So now they can't do it. But my own problems and my own difficulties in getting this resolved through the Advertising Standards Authority, repeated complaints. As I've progressed, I've got stronger basis for it. Till now, it's absolutely certain. And Ofcom as well are meant to play a role. And currently, Ofcom aren't upholding British constitutional rights. They're playing the side of the Americans and trending towards this... the basis of the Digital Media Act, and Parliament are refusing to help. They're refusing to contact YouTube and make people put their material back on. Yet when David Davis MP of the House of Commons had his channel removed, taken down, it got, someone contacted YouTube and had it put back up again. But we're not getting that. We're not even getting them acknowledging for e-petitions. Now, before I get on to like Russell Brand and other channels on YouTube and why Ofcom actually should be acting to protect us, and all of the material that I've sent attached to the email, what are those images even? Why have I sent images of like a winking elf book and the Google main page and, the latest Doctor Who programme? What have they got to do with all this? Well, I can perfectly explain that when we get on to the part about the responses from the platforms. How are these platforms operating? What powers have they got and what powers are they using? What are they doing to people? What are they doing to users? And what motivations have they got behind their actions? And now they don't even have to give clear motivations. They can give very random and unspecified reasons, which they don't even have to justify, respond, or reply to. And there's not really much you can do about it when they're in America. Yet, I will carry on with this subject, even though I was going to say I wanted to save it for later. Because what the platforms are doing is they're being political. They're engaging in politics, and they've got massive powers to completely censor and inhibit it without even any dispute, not even in a court, right? Not even in a court. You don't get them into court in England, and not even with any dispute, no response or anything. So they're arbitrarily using massive, complete and total blanket censure, and if they wanted to, but they're doing it through monetization, and they're also actually intimidating certain petitioners. And that's where those photographs come in, because I have got an existing issue with YouTube that is real and exists, real and existing complaints through Ofcom, advertising standards, Parliament, to them directly. They know it's serious, they know it's an issue, and they know that this whole contempt, the contempt against petitioners, is real, and it's a very important, serious issue. And now that I've found out that that act doesn't protect them at all, definitely not in England, and I don't even think it really does protect them in America, because it's flawed. It only can protect them from people recovering financial damages. And actually, it turns out that if you understand the law properly, they don't have a right to remove constitutionally protected material at all, because that is a criminal contempt, not civil, and they're only protected from civil actions, right? So YouTube are in the bad, and I've only really been affected since Neil Mohan took over. Since Neil Mohan took over from Susan Wojcik or whatever she was called, it's when my channel got taken down, and I didn't have any problems with it at all. But it's not just the fact it's been taken down; it doesn't really too much matter if it doesn't get put back up. It's the fact that I can't access my data, I can't download it, they won't even let me log in, and that is where the grievance is. It's been unlawfully seized for 2 years now. And it's criminal in England. This is criminal, and you know, their platform operates in England under English law, right? It is contempt, and because they know that it's really serious, this issue, right? Is when they're starting to do things to put innuendos out and acknowledgements and making a political statement with an image, right? Which is what we all do when we're using political rights. But they're not supposed to obstruct other people's political rights. So the issue with those images that I've attached and sent to advertising standards, and it's not really a matter for Ofcom, because really, when it's political to do with your proceedings to or in Parliament and your political material for that purpose, it's a matter for Parliament. So that means a matter for both the House of Lords and the House of Commons. And really why there needs to be a member of the House of Lords on the board for Ofcom, because really members who are on the board for Ofcom, you know, there are going to be parliamentary matters undoubtedly that arise on a platform, and if they've got someone on the board who's a member of the Parliament, then that to me would be the perfect solution, which is, you know, why this video now is being recorded and a statement made, right? And I'm even going to end up tying Jacob Rees-Mogg into this because of comments that he made in the select committee to do with how e-petitions is run and what our political rights should be. And I have already complained about Jacob Rees-Mogg being on GB News against the historical election laws and what the historical election laws are meant to mean, and how that translates into modern, you know, GB News and platforms. So, in fact, what I think's happening really what I'm trying to, so the overall picture is, so what is the claim in its major part? All these other arguments are attached matters to it, like, are e-petitions protected by constitutional rights? When we put e-petitions on the internet, are they fully constitutionally protected? And should Parliament act? Should the ASA and Ofcom act? Are they acting? No, right? And then, what I said about Lucy Fraser, what she did actually is effectively what committees aren't allowed to do, touch on political cases unless the Speaker gives them permission, right? What Lucy Fraser did to Russell Brand is the reason why they're not allowed to talk about those and affect the persons, because Lucy Fraser affected Russell Brand's financial income and really it did affect his financial capacity for his case, really. And that's the reason why that Parliament shouldn't do that. Unless the case has been raised to Parliament when they had, appeals to the Lords, unless they appealed the whole case somehow by petition to get an act put through, to, make Russell Brand, acquit Russell Brand or whatever. There are various possible things, but that's not on scope now. What's on scope is, right, that YouTube, Amazon, Facebook, Google have got themselves a massive entity and loads of money. They've acquired themselves a huge entity and force. And that force, not unlike the newspapers or television, when everyone's using it and when it has a controlling effect over society that can possibly be equal or beyond Parliament, politically, that's why Parliament control elections, right, and election material. Otherwise, the TV could be the sole influencer of elections or the most powerful influencer of elections, right? Now, these platforms have acquired themselves a political opinion. And that political opinion is, we need to protect ourselves, because what if these people suddenly said, hey, what if platforms should be owned by the government? Or, hey, what if platforms should be completely and totally free? Or what if platforms should be ad-free? So the platforms have got their own interests, right? Just like companies have when they do private bills and so forth, right? But when your business is, look, if all pen makers went on strike, so no one had pens and the police couldn't write with any pens, right? The police wouldn't, how would they write? Would they seize pens? It's on par with that, The platforms have acquired themselves a political position and they've realised that they need to protect it, but there are constitutional rights. Now, was that Digital Media Act for indecent material in America really done to protect people from indecent content? Because, they still have indecent content in movies, horror films. All it has is an age restriction, right? There's some gross and horrible stuff in movies, but it purely has an age restriction and then it's shown after a certain time. Political material is of equal right as any 18 film, but without a particular watershed time, right? But they're saying that they can just remove anything, right? I really think that the Bill Clinton movement was to try and give itself a partisan wish power, a partisan power, a dream power of being able to completely and total censor all of any political opponents, and mainly independent ones, right? But obviously they're not bold enough to completely censor their opposition, the other parties, because, that's the main convergence of the powers, where they converge together at the kingpin point when they converge. So they both lean on each other, really, for that eternal contest. So they can't completely political sense of the other side, which is why election rules have to be fair, right? But what is actually happening is our equivalent of election rules for the independent person, for the citizen, for the petitioner, is that they're saying that they can completely and totally censor us every time in a row if they want, and that can't be fair, or demonetise, right? Or say it's not eligible for monetization, but but yet all these other political parties are allowed to receive money and donations, right? But they're still not for profit. The intention is meant to be to affect political change, not to make a profit. And to affect political change, surely you're allowed to, make money, right? But these platforms don't want to give money to these particular channels anymore, like Russell Brand or Richard Verbs, right? So this is it. Now, the thing is that so this censorship actually is causing a political obstruction, and it's an illegal one because of this. It's an illegal one because of this. It's contemptuous because it's actually physically hindering, blocking and obstructing the process, right? But not just that. It's got to the point where, because people are like, okay, what shall we do about it? What can we do about it? They're needing to act. So they can only act by, starting other channels or trying to bypass it, or making images, making statements, making political material like images, or making a political point. They're doing it about Keir Starmer now and so forth. Now, this is where we draw in those pictures that I've got, because what Google are doing now and the big platforms, because they've got all these apps on our phones, we're all using their Google Drives and Gmail and all their things. They've got access to our data and information, right? And they're forcing us to consent, submit, accept to them accessing all our photographs, images and data. Even now, as soon as you take a photograph of something, the Google ads were showing up images. Like if you took a photograph in your garden of a red car, then as soon as when you go on the internet, like even up to 2 minutes later, when you're going on Google Ads, the apps on your phone have already seen the photograph of a red car and they're showing you suggestions for it. So they've got access to the data, right? And that's just for everyone. That's for everyone, not just special people. Like I'm trying to claim that, I've got some particular or unique claim. Now, my claim is that because I have stuck my head above the parapet, or because I have had a very prominent, strong claim against YouTube to do with the rights and the fact that it's contempt, and, since Neil Mohan took over, right, and that I am a person with a very strong claim against YouTube, a very prominent grievance, and it has very serious consequences if it's contempt on their staff, right? So this is really, a thorn in the side, depending on how long they can ignore it for, depending on how long Ofcom or advertising standards refuse to act, depending on how long the MPs and Parliament refuse to act, when there are contempts here, right? And these contempts here aren't just obstructing, intervening the process. They're actually, it includes harassment, intimidation and deterrence. Harassment, intimidation and deterrence, right? So that's when my complaint comes in with the images that I've used and attached. So how can YouTube, how can they intimidate you? Well, they can literally, get hold of your personal and private information, including images, right? And they can make good use of it, possibly even against you. This is what people usually do in political causes and campaigns, right? If there's an animal getting hurt, they use that image to say that animals shouldn't be getting hurt, right? Now, they have, there's no doubt about this, that Google image from that moon, they've gleaned the information intentionally and knowingly from a book that I did, right? The Quilt Elf book, right? And they're using it to make a point on there, right? And I think it's intimidating. It's intimidating because they've got my personal private information. They've made use of it themselves to inspire them to do an image, right? And it's making a point. It's making a political point that we got the power. We know what all your images and things are. We know all these things about you, and you're trying to get action against our platform. Well, this is what we can do, right? And then it's got the winking thing, like, and even actually the BBC have in the latest Doctor Who, the one with the planet Belinda on there, they've put this generator thing with this winking cute character, and the basis of the Doctor Who programme, the meaning of it is that the front is this cute character, this cute sort of winking generator thing, right, on this planet, but then inside it is this villain, this evil character, right? And that, I think that is the motif for Google. Like, they've got all these, cute images and cuddly things, right, particularly that they use on their homepage. But behind it, you've got Sergey Brin, right, and the other people. And what they are is they're tech people who have been really trying to, take over the global market with influence and control with these big platforms. And also it's tied into investors. Like, you get onto the whole BlackRock Vanguard issue that people have been raising. Other big companies like Amazon, Jeff Bezos, Facebook, Mark Zuckerberg, the Senate have got him in front of the Senate for working with China now, supposedly, Chinese government. And, McDonald's, all those companies which are owned by BlackRock Vanguard shareholders, like McDonald's. And I've got a complaint against McDonald's as well, right, for the theme tune that it's been using, which also copied off one of my things, and I've got very strong evidence to prove that with Advertising Standards Authority complaints, right? And people like Russell Brand, I am not like Russell Brand because, firstly, I didn't want to, be high profile, but my cases are strong profile. You don't have to be like high profile in numeracy of viewers to have strong, compelling cases behind you against these big entities, right? Russell Brand has been demonetised, and the government played a role in that. Lucy Fraser played a role in that. And then, Vobes has been demonetised. He's someone that the government isn't necessarily fond of because they're pushing these certain ideas politically and trying to get people behind them, like, Dr. Tess Lowry, Neil Oliver, people like that. And these views and opinions are not in line with these platforms, so that they're punishing them through either deleting them or demonetising them, right, one or the other, or intimidating them. And I am a victim where I didn't really have loads of viewers or fans, right, and then they took demonetisation from me. I never even at first applied for it because you had to apply for it, but they said that I wasn't eligible for it early on, so I've never been able to generate much money or funds. So, but yeah, it's a petition campaign, and they're actually using their surveillance spyware powers, all of the access to your apps that they've managed to coerce, accept, consent, submit from us over time, gradually slipped us into this consent, submit, accept policy. And then once you're addicted to the phones, to the devices, and you don't want to give them up, or you can't do without them. So what are you going to do? If you don't continue to accept the policies, it is entrapment in a way, long-term entrapment. So they're using all these surveillance things, and probably as I speak now, right, and they're using knowledge, information about individuals effectively. They're using information and knowledge about individuals, right? And when these individuals sort of like, stand up against them, right, they effectively squeeze them, which is another theme in Doctor Who more recently. The BBC are all over this when they had the big cannon on the top of the big government building where they can pick people off, like, and target them, with a big weapon. But the weapon is the banning, demonetisation, Now, the government are working with these platforms, they're cooperating with them. They have them all in for meetings, and they come up with a policy together, right? This censorship of constitutionally protected material is illegal. The American Act is not even valid for it, really. It is only enacted in its wording to protect against financial recovery, right? Compensation or injury caused. It isn't enacted to actually allow those platforms to really remove it, because when you have got a petitioning process, a civil process, a legal process, it's protected. And this is where this contempt comes in, right? And them intimidating us. You know, what another thing they can do is, because they record keystrokes and because they get data from a usage of a phone, right? This is another thing, Michael Grade, right? If if this ever gets to your ears and you ever listen to this, right? What they can do is this. If you're using a phone, like an Oppo phone is what Google own Oppo. I never even knew that Google owned Oppo, but Google even owned my phone, Oppo, right? Any apps on it, any of the Google apps, Drive apps or Notepad, right? If you like an app and if you use it a lot, you press certain buttons, and those buttons are user-friendly, comfortable, and convenient, right? Yet, if they want to target a person, like Russell Brand or anyone, if they want to target a person, they can even look to see what buttons they like, what are their favourite buttons, what do they use, and they can change them. Because there's nothing more annoying or upsetting than an app that you like and use a lot, and it's user-friendly, and then them changing it. So when you were used to using it and it was comfortable to use, like Prince Harry with the helicopter, all these buttons are in the right place and touchy-feely, right? People don't switch his helicopter control, so left is right and right is left, right? It's actually disrupting your use of the phone, okay? So they can even do that. They can find one of their opponents and say, oh, he likes that button, right? He's using that a lot. And then just change the whole app, so moves it to the right-hand side or to the top. And you're like, I liked it there. Why have you moved it, right? When there was no reason to do it. Same with design, all these Amazon, logos. These, and then how can you portray that thing? The thing that is, someone doing something like that to you, and you not really being able to prove that they did it and targeted you for a identified reason, right? And then you look at the Amazon smirk, the Amazon smile, the Jeff Bezos Amazon smirk. That's funny, but this is happy. This is a happy app. This is happy things. It's happy, but it's got a sinister flavour to it, right? It's got a sinister flair to it, okay? And this is what's happening with these apps, right? They say they're user-friendly. They say that, they're for our benefit. But all these weird, strange and sinister things happen, which never used to happen before. And it's as if there's some kind of like smirk to it from the machine, from the device, like it's doing the McDonald's whistle, like, or something like that. Kind of, it's positive, but in a sinister way. And this is what is happening with like these Google things, And it's hard to prove it, but I believe they're targeting people. I believe they're targeting people politically, and they're not declaring it a political cause. They're not declaring it a political reason. Instead, they're just making up excuses, or, it's very hard to contact them now. It's extremely hard to contact Google. They want to put you into the community to solve it. They don't want you to speak to them. They don't want anything in writing. If you can send a message to Google and put it in writing, right? So it's in writing, and they've got to have a response. You can use that in a court, and all these new platforms are using that strategy that they don't really want you to be able to put anything into writing or the least chance as possible. They think up of the questions and they think up of the answers, right? And when you do put an appeal, you're restricted to like one paragraph, which is exactly what the petitions committee are doing as well. And I've got an entire argument about how the petitions committee is being run and what its policy is and so forth. But that's the key to the whole right. Firstly, we do have this right. It means this. This is what this right is and what it protects us from. And also, these are the type of problems that you might encounter. And this is probably the strongest bit of evidence that I've got to Michael Grade now. And the reason why I'm recording this and the reason that I'm going to email this to Michael Grade, because it says in here that persons doing important, serious political campaigns petitioning to the High Court of Parliament would be the most likely people or the people who would be targeted, and obviously the larger your opponent is and the more money your opponent's got and the more power your opponent's got, like Google or YouTube, right, then the more you are likely to have intimidation, deterrence, or people trying to intervene in your proceedings, right? Now, the fairness in proceedings is that everybody's allowed to do them, right? For political causes, everyone's allowed to make a representation, which is why the election rules are fair. The election rules are fair for everyone, okay? Right? And what is happening on the platforms is that it's not a fair arena because these platforms have given themselves, and the government haven't as yet intervened or stopped them properly, they've made it so they're removing things for any reason or no reason without an explanation and literally extinguishing potentially all of their political opponents. Although if Russell Brand and Richard Robes and more and more of them were actually taken off there, they've already dipped their algorithms and stuff. For their algorithms, people on Facebook are saying, we've got less people viewing the group or joining the group now and so forth, right? Now, if these platforms completely and totally replace the newspapers, then we've got a potential for a complete political blackout, right? We have got the potential for a complete political blackout for any reason or no reason, supposedly. But that is not the case. And it's not the case because in this country, YouTube don't have a Section 230. But the government are not enforcing this right. They're not giving us enforcement, and they're not helping us or supporting us to have content restored or returned. Judicial Conduct Investigations Office have tried with, like a subpoena, right? Google just won't respond to letters, don't respond to letters. Advertising standards, I've got enough evidence to prove this is the legal fact and truth now. I've got enough evidence with the Advertising Standards Authority that this is really serious constitutional crimes against us in England, but they haven't made them put the adverts back up or grant access to the adverts or material. Ofcom haven't, and Parliament haven't. And as if it's contempt of Parliament, Parliament have got an obligation to act. Now, so the only argument is that, we don't have the constitutional right, In England, not having the Section 230 like in America, which I don't think is even legitimate anyway, only for financial recovery. In England, we are protected. And the government actually, Lucy Fraser acting against Russell Brand, Petitions Committee actually being worse than YouTube, really. The policy of the e-petitions actually is the model for this whole thing, because now they're rejecting things on any issue that they want to pull on it and then just saying it's standards, and they've made a policy. By the way, that policy and agreement is only signed by 2 MPs, the Leader of the House of Commons and the Chair of the Petitions Committee. And that policy has got staff who aren't elected. They're not clerks of Parliament, and they are rejecting things, and they've been told in the policy that they don't have to give a reason or any discussion about it, okay? Which means that you can't get a statement from them which you could use in court. Not that you could use it in court anyway, because Parliament has got privileges, but you could have a strong argument with, your MP or the Prime Minister, right? They're not elected, those staff members of the Petitions Committee, yet they effectively are, they can block you every single time for any reason or no reason, and just say that it's all standards, right? And they're even trying to tell you how you should write it and what words you should use. And these are prayers and statements which are, in legal terms, constitutionally protected, right? And I actually think that what the Petitions Committee are doing now is a contempt against Parliament, because they're attempting to obstruct, deter, and put you off doing certain things. Now, so the Petitions Committee really is almost like the mini YouTube, but worse. It's actually worse, YouTube isn't quite as bad because some people are still actually on there, even if they're demonetized or even if they had 1 or 2 videos or some videos taken down, they might still manage to be actually on there, right? But the Petitions Committee is almost like pioneering this. Now let's go into the Petitions Committee, because this is where we bring Jacob Rees-Mogg into this. And I've complained to Michael Grade about Jacob Rees-Mogg on GB News, right? Because, after all, there's a lot of... I think the rules for the parliamentary elections have been broken because they're providing entertainment. And I've done actually a thorough video onto how and why it is entertainment. And in all of the historical acts of law for elections and petitions, it's illegal. Only in the modern acts are meant to extend on to the basis on the previous acts, right? Right, so this is my notepad, actually. This is the app that I like quite a lot. So this is, we're at 45 minutes now. I don't really want it to get to an hour long, hopefully, or else I don't know if Michael Grady is going to listen to this, right? So, Jacob Rees-Mogg, see, we've even got things popping up at the top of the screen there while I'm talking. Jacob Rees-Mogg, this is key to actually the whole thing. It's ironic that I've got a complaint against Jacob Rees-Mogg for being on GB News, right, against the election laws for providing entertainment. And, the entire Ofcom policy and rules are ignorant to the full fact of the law on this, right? For e-petitions and proving this, the extent of the privileges is what's going to actually be the deciding factor on these platforms, that they shouldn't be removing our material in England and that it is a contempt. And it's such a serious big issue that threatens them with criminal contempt that these random members of the public who dare to bring these challenges, very powerful legal challenges and claims against YouTube, who are a thorn in their side, who's this? Who's this contender? Who's that contender? Who are these people? And that's why I believe that they're having, who is this person looking at all our stuff and saying, and then putting out these images, using our information and images and using it against us, which is, as I showed in that parliamentary practice book, in that section, is misconduct against petitioners. It is misconduct against petitioners. Demonetising Russell Brand when he's got a strong political presence on YouTube, and when he had a private personal legal case, what might have needed to be funded by that money. Lucy Fraser is breaking the law there for sure. Absolutely, for certain. There's no doubt about it. But we've got to prove that the privileges extend to canvassing, which obviously they need to, because for elections it extends to canvassing because it's the law of parliamentary agency, right? And if the newspaper, it covers the newspapers when something's been done with and finished with, anytime it wants to be quoted or commented or spoken out loud, then it must apply to, the procedure by which you get it into Parliament and get it debated, collecting the signatures and raising awareness of it. Otherwise, you can never end up with the end product, which is the fully protected newspaper article, fully protected, the Parliamentary Papers Act can be used on YouTube, actually. Parliament, but you can't get them into court anyway, But then they're not bringing court proceedings against us. What they're doing is they're managing to exercise justice somehow, or it's not justice because you don't get a fair trial, but it's better than justice because they don't even have to go to court and explain themselves or give any reason or come out with a statement. So they've got a juggernaut of a tool at the moment which they're heavily abusing. It's completely and totally illegal. It is completely and totally illegal and in contempt when it comes to, like, my channel for a start. So, let's go to, the political right itself. And let's start off with e-petitions, right? Because that was one of the prominent official online processes, which most definitely is published by Parliament, because it's got the Parliament copyright on it, right? Okay? This is Rees-Mogg speaking in the oral evidence in HC 235. Jacob Rees-Mogg in the e-petitions oral evidence of HC 235. He says that is right. This is in regards to e-petitions, right? They are using this right and that is completely privileged under the Bill of Rights. Well, that's the right to petition, the Bill of Rights right to petition, that we can't be prosecuted or imprisoned, okay? The question is, how do you limit that right, which I think we obviously need to do? We do not want vexatious, libelous, or sub judice petitions. But this is the thing. You're allowed to. You're allowed to, because they're protected from being prosecuted against or imprisoned. And this is the thing. Prosecuted against means proceedings initiated, which means a claim against you in law, right? And the thing is that the Parliamentary Papers Act completely and totally protects, okay? The Parliamentary Papers Act protects, and it allows for libelous, vexatious or libelous. It allows for it. It actually protects against it if it ends up being in there. It wouldn't get in there if you weren't allowed to do it. Either you're allowed to do it or you're not, right? But how does it get into Parliament? How do those items that get protected by the Parliamentary Privileges Act get into Parliament anyway? They don't just like appear from nowhere in there. Well, they come from people who submit complaints and petitions, right? Or raise an issue with their MP, or else it cannot be in Parliament to come back out the other side again, right? So that is the thing. And what Jacob Rees-Mogg is actually doing here, what he is actually saying is that we've got this right. It is the constitutional law of England, but we, the MPs, wouldn't it be great if we could somehow limit it? How do we limit it? But what is limiting a right that you constitutionally have and cannot be subverted? Well, surely that is interfering with, or trying to obstruct you in your campaign by taking the rights away. So surely, on the basis of the previous document I showed you, the contempts against petitioners, what Jacob Rees-Mogg is suggesting is that the ministers should engage in contempts against the petitioners by taking their rights away, restricting or inhibiting them or obstructing them. They want to. They're saying, they're admitting that they want to inhibit, obstruct, or interfere with the rights and liberties in the process. You're not allowed to interfere with the process. Okay, you can't interfere with it. But what they're trying to say is, "Oh, wouldn't it be great if we could? Let's think of a way to do it." Well, that's contemptuous. That is the contempt. And in the end, if you actually go to that document, HC 235, not the oral evidence, but the actual select committee review write-up, they end up coming up with a policy. And the policy doesn't actually have a clause in about privileges to disallow them or inhibit them, right? It doesn't. There's no policy clause in there, really. But they've got other policy clauses, like they don't have to respond or give you a reason why they rejected it or won't dispute it, or the fact that they can reject it, right? That's actually inhibiting the right. Now, where does that policy agreement come from? It's not in the constitutional law, it's not in an act, it's not in the standing order of Parliament, and it's not in a resolution of Parliament. So it's actually only in the policy, an agreement which was created, and it is only signed by 2 MPs. It's not even signed by a majority of a committee, and not even 2 members of the petitions committee, right? It's mainly an agreement that they force us into and that they're putting on there, that they won't have to respond to anything or give a reason, so then you can't get any evidence, against them, that maybe it's not a true claim. And the fact that they're saying they can reject it or remove it, which stops you from showing it to the public, which is in your right to do that. So they really have created themselves the ultimate partisan dream machine, really. The ability to reject every single opposition's claim and prevent it from getting heard, right? It's like the parliamentary dream power for the partisan dream power, right? And effectively, that policy, it's not the law, and it's not a standing order, and it isn't a resolution. It's merely something that a committee came up with and said, oh, why don't we get 2 MPs to, like, sign this, every parliament, right? And therefore, it's got no legal basis on it. And it is against the Constitution. The policy is contemptuous against the petitioner because the policy is obstructing people. And, Jacob Rees-Mogg said, wouldn't it be great if we could, limit the right. Rees-Mogg said that Parliament and the MPs want to limit the right, but yet we've got that right and it's the law. So if I limit someone's right, when it's protected and it says that to try to limit what they're doing would be contempt, right? It is contemptuous. And this is so big that I can't, how is this going to get dealt with? No one even wants to openly admit it because it's so big and serious and important. And because they didn't change the law, and because they didn't come up with a standing order, and because they didn't come up with a resolution, and because it's only a policy, and because the constitutional law actually it protects us, the only way that in reality Parliament is limiting our right is by not giving us it. It's not granting us it. Because it's not even, and the thing is that, that they're trying to say that, oh, well, the petitions are only protected in proceedings inside Parliament. But according to Parliament, every single person who goes into Parliament, everyone who gives evidence in Parliament is protected, right? For everything, even select committee evidence, whatever. So if you were to say that, well, that's just what the petitioning right is. Well, no, it's not. The petitioning right has to be something specific to petitioning and what is needed for petitioning. The petitioning rights aren't the exact same rights as everyone gets when they're in Parliament giving evidence, because then it would just be the rights that protect people when they're giving evidence in Parliament, right? And that's not the right to petition. The right to petition protects all proceedings, documents and things required to do to facilitate that process, which is canvassing and possibly even, being able to get some sort of evidence or whatever for a statement or whatever, right? And hear it, So, and Mogg, in that HC235 paper, what Jacob Rees-Mogg and the rest of the committee are doing, what they do is they have 2 pages worth of dialogue through 4 or 5, 6, several paragraphs, and they're downplaying the extent of the right and what the privilege actually covers and extends to. And they use a persuasive argument only. It's purely persuasive and it's purely opinion that maybe it only protects people actually inside Parliament during proceedings inside Parliament, right? And then, if that right had to get upheld and enforced, they're trying to make out that, maybe that they wouldn't have to do anything outside of Parliament, like, help us with our canvassing or, enforce any rights in the court or on a platform or anything like that, right? So, but that dialogue from Mogg and that evidence wasn't actually put into a policy clause. None. But if you read the paper, then it's persuasive that, you're not going to get any help with anything, right? Let alone actually getting it published, right? Which is the main obstruction that they wanted, because if you can't get it published, no one can hear about it, right? Except 5 people that you share it with. So it's the absolute, complete and total partisan dream power to if you could stop your opponent from debating every single time and everyone from hearing it for any reason or no reason, you would effectively not have an opponent. There are no opponents, right? You could just make them all vanish. So I think it's important. This is very important, and Mogg actually says here that the people are completely and totally protected. You can't say that people are totally and completely protected when they aren't, but then say, how can we limit this? But there's not really any way to limit it, Mogg, because that would be contemptuous, wouldn't it? Because that evades the point in having the right and its function, right? So, I mean, this is it for Mog. I mean, I've got all kinds of stuff here, like, you see here in the Parliamentary Journal, I thought this was Hansen, but it's the Parliamentary Journal in 1837, August to July, on page 1270, right? Because in his case, as in others, the privilege of Parliament protected the presentation of the petition, the printing of it, all documents connected with it, at all, accusatory evidence given at the bar. Well, all documents connected to it, they don't have to be annexed to it directly, because you might get called into Parliament at a later stage to give the evidence, right? Whether it's oral evidence or articles, right? Just like in an inquiry. So all that has to be protected, no differently from any other legal case. So I've got one from a Mr. Wakely here. This is Mr. Wakely, right, talking in the Parliamentary Papers Act proceedings for Parliament, right? It's in the Hansard debates, 30th of May, 1837. Mr. Wakely desired to know if the proposed bill would allow to the public generally, if the public bill would allow to the public generally, if it would permit individuals to be allowed to republish any petition or report that has been issued from their office, right? So, you know, the e-petitions are published while they're open because it's got the Crown copyright on it, and it's made available to the public, or the public, a section of the public, or the public at large, in whatever form and by whatever means. So it's on the Parliament website. It can't be on the Parliament website and available to the public with Crown copyright on it without being a parliamentary paper. There's no doubt about that. No matter what jargon Rees-Mogg wants to try and pass through, it is a parliamentary paper, and it is protected, you know, while it's collecting, or you won't be able to canvass. And this kind of new special power or right they've granted to, not even to MPs, to these mysterious 4 members of staff who apparently might be on £200,000 a year between them, which could be over £900 a week each, possibly up to 4 people, on a mere policy clause, which gives them the right to potentially reject every single petition a person might ever submit on a very loose claim that, oh, it's not to our standards, without having to enter into any dialogue about it. That's what YouTube are doing. That is what YouTube are doing with the removal of videos, right? And that is not democratic. This is a partisan superpower to completely block all of your opponents, potentially forever. All of them, potentially forever, every time, and completely silence them, and actually to not have an opponent. And I think that the main 2 parties in Parliament, the Conservatives and the Labour Party, they both leaning on each other, both leaning on the opposite direction, but they both form this, you know, this structure. This is a way to completely and totally extinguish all true opposition and all strong opposition permanently without having to be accountable for it at all whatsoever, right? And it's wrong. And, you know, I think that the Petitions Committee exists now only to make Parliament look like it's been democratic. It's more like sort of, it's like a kid's toy water gun, you know, rather than having sort of like a real, you know, gun. Not saying that you should have a gun or shoot anyone, but what I'm trying to say is that it is like, it's more like a toy. Sure, you can get something published and you can get signatures on it, but the vast majority of those petitions don't. And anything that would be strong to get signatures, they block it. And it's only these odd petitions now and again which get signatures or manage to, because of the because potentially you've got a chance to beat these political parties, just like you've got a chance to beat the platforms, really. All these, you know, Russell Brand and Verbs, whatever. What if they started to say that, you know, maybe everyone should, like, you know, say that the government should own the platforms, like Jeremy Corbyn wants to happen, or maybe they shouldn't have advertisements on them at all. maybe, and what the policy should be, for political speech. These platforms don't want us to be able to decide, not politically. They want to dictate the law, and we're not even getting to court. They've managed to create a new society where you've got these arbitrators with massive power. They don't really have to give any true detailed reason or any dialogue, so you can't really get any evidence against them that their argument was false, right? And they totally... it's not justice. It isn't actually justice. I think we lost justice a long time ago when the juries were removed from the civil courts and the magistrates. You only get a jury in a Crown Court now. And I thought magistrates were bad coming to decisions and applying the law, but this is worse because we don't even know who these people are. These people are in another country. They don't, it's not even our country. So effectively, you've got someone in another country which has got totally different laws, who is making judicial decisions, really, and punishments on you when you're in another country like England, right? YouTube should actually be made to have, a legal office in England, and all judgments are made by English law in that country, not Americans supposedly applying English law. And this is like all part of the New World Order to try and create some kind of standard. But yeah, the standard is meant to be the Americans, right? And they have got a constitution, yet for some miraculous reason they managed to, apparently it can even be removed if it's constitutionally protected. But as it turns out, it can't because it's a criminal contempt. So anyway, Mr. Wakely definitely thinks that the Parliamentary Papers Act is connected to petitions as well. Not just things that have been ordered to be published by the Parliament. And Rees-Mogg here is giving evidence that we are completely and totally protected, but they would seek to or like to somehow be able to restrict it. But they haven't, not in any, they haven't they haven't voted on anything in Parliament that would do that. Merely, a committee came up with, a policy, but did it get voted through the House? Why do only 2 MPs have to sign this policy? The Leader of the House of Commons and the Chairman of the committee. And these people are not elected who are rejecting our petitions, We don't know who they are, what their political opinions are. And they've been seeking advice from different departments of government. We're in opposition to those departments of government. You don't ask your opponent if it would be okay if you could use this, certain very strong evidence against them, right? Which really, I think, is why all these people are being censored on the platforms, because the government really doesn't want there to be an emergence of these strong opposing forces, right? And I don't actually necessarily think it's about the language, because, the Richard Verbs and Russell Brand channels are perfectly okay with the language. It's about their ideologies and what direction they want the country to go in. So I think I've about finished now, but that's about 1 hour and 7 minutes. So, I mean, my personal complaint is that Google and YouTube are they're intimidating me. They're intimidating me. And they're using their surveillance capabilities of all my apps and things like that I've had to consent to access information which they can sort of use. And, I've had one channel completely and totally removed, unlawful seizure of my articles, and Ofcom and the Advertising Standards Authority, because some of those are advertisements, promotional, then they're not acting, they're not doing anything. And the government aren't. This is Parliament. It's a contempt against Parliament. And Mogg is actually affirming that right exists and is in force. And there's no change to the constitutional law or any there's no act of law for the Petitions Committee, right? So, Michael Grade, House of Lords, House of Commons, this is a Parliament remit. Contempt against petitioners is a Parliament remit. And, where is there a member of the House of Commons on Ofcom's board? I know there's at least 2 members of the House of Lords in there. In fact, I should email the other member. I don't know if he's called, is he called Allan? I'm not sure. I'm not quite sure. I can find out now, though. Ofcom board members. Okay, so this will show me now. I know there is another member of the House of Lords. Oh, it's Allan, Lord Allan of Hallam. So I suppose I'll have to send this to Lord Allan of Hallam as well. Oh yeah, I think was one of them an MP. I think that Melanie Davies, I don't know if she's an MP now or not, though. People have been complaining about that Melanie Davies. So, these executive board members, they're all equivalent. I think they're all Democrats, the equivalent of an American Democrat like Joe Biden, and the leaders of the platforms who are part of this huge global attempt to change governance as we know it, to seize. They're not just seizing our articles, protected articles. They're seizing the government from us. They're actually seizing justice from us. And without any democratic vote or change in law, the government are thinking, hey, wouldn't it be great if we could have justice without courts and we could just have, our private corporate pals and friends just deciding what should and shouldn't be on the internet or what everyone should and shouldn't be doing. And then giving each of these blocking and banning buttons when, one person themselves can sort of act as if they're a jury of 12 people and, block people from places or even groups. And it's no one is voting for it. It's just big companies who have just, started up and they're not even facilitating the debate on there really, truly, because if they can remove you, it doesn't even comply with the Public Meeting Act. And for sure, the right to petition has a legal effect on the Public Meeting Act that people can't be broke up when they're having political discussions and debates. So the main part of this is the American part of it, because that Section 230 of that Digital Media Act for content is only in the wording protection from a civil action, not from if it's them. When you have got a case to Parliament, it is regarded as a civil case to the Parliament, but it's the intervention and the interference in that which is a criminal contempt, because it's always a criminal contempt when you disrupt or intervene in legal proceedings. It's only a civil contempt, like if you break an injunction, right? The order, right, from that particular thing, right? So, that we don't even have that Section 230 in England. So we need to. So what do we want? Well, firstly, I'd like some action against YouTube and Google for their intimidation and harassment. And I want my access to my content, even if they don't put it back up again. That content's got a legal right to be on there, but I don't even have access to it to log in, to get it, to access it. And that is the main thing, illegally seizing it, And then we've got all these issues with Rees-Mogg. And a lot of these MPs, I think, they're not completely protected by parliamentary privilege, because when they do certain things, that is a breach of their privilege, right? And they're meant to be punished for it. Jacob Rees-Mogg has definitely put it on the table that there definitely was a plan, a strategy to attempt to undermine the right, which is contempt. When the right is existing and is in force, it has functioning requirements that are required for it. And they're saying that they want to somehow, they don't think that we should have those functions and requirements that the right is there to do, which is no point in having it, right? And that they should be the arbitrators of it and should control it. And the way they're doing that is just by not granting it. When you say, we've done a protest somewhere, we got arrested illegally, can we have some support? They say no, or even saying you don't have a right, or it doesn't extend that far. And so that they're lying and giving misinformation. But Mogg admitted that it fully and completely protects. So Rees Mogg is lying to himself, you know? And then we've got all the issues with Mogg, with GB News to add on top of it, which is a separate complaint. So that is the extent of my complaint. And it's quite, I think it is probably quite extensive and complicated, but it is it's the entire fully encompassing issue of actually, you know, getting your petition going and creating it and getting out there on the platforms and what these platforms doing about it, and what about other people who are similarly engaging in political activity and the platforms aren't keen on it, don't like it, and they want to remove it for any reason or no reason or demonetise people. And then even Lucy Fraser is, you know, putting a foot into it and affecting a man's financial means for his legal case, which can't be good, really, because MPs aren't allowed to touch on legal cases in there until they get permission from the Speaker, right? They can do. That's the whole point of being privileged, you know. They're saying that we don't have the right to talk about ongoing legal cases ourselves. But if you put a petition into Parliament, you know, that's one of the reasons why they're reckoning they're censoring our material. But if newspapers weren't reporting on legal cases, we wouldn't know about them in the first place to oppose them. You know, we wouldn't even want to do a petition that touched on a legal case if we hadn't first heard about it, because how would we know about it? So the newspapers are, you know, the only means by people know about it anyway.